A major Supreme Court decision just landed, and it is already transforming firearms licensing rules across every single state in the country. Millions of gun owners are impacted right now, and most have absolutely no idea yet. If that subscribe button is not red, tap it now, and let's break this down. Background of the case and how it reached the High Court. For decades, millions of ordinary Americans attempted to obtain a firearms carry permit and left with nothing. Not because they had a criminal background, not because they posed any threat, but because the system standing between them and their constitutional right was deliberately constructed to be costly, slow, and nearly impossible to navigate successfully. In some of the most restrictive states, the approval rate for carry permit applications fell below 1% for regular civilians outside of law enforcement connections. Consider that number carefully. Out of every 100 people who applied, 99 walked away rejected. These were not dangerous individuals. These were teachers, nurses, truck drivers, and parents who simply wanted the legal ability to defend themselves and their families. Gun rights organizations had been monitoring this pattern for years and constructing legal challenges around it. They gathered data, documented denials, collected testimonies from real people, and began filing lawsuits in courts throughout the country. Most of those early cases collapsed. The legal system kept discovering ways to avoid the core constitutional question rather than confront it directly. But each unsuccessful case taught the legal team something valuable, and they kept strengthening their arguments, kept building more compelling records, and kept pushing cases higher up the judicial ladder. What made this particular case the one that finally broke through was not fortune. It was years of deliberate legal strategy layered on top of a foundation constructed by prior rulings that had already begun shifting the constitutional framework in a favorable direction. By the time this case arrived at the highest court, the justices could no longer avoid the central question. The record was too powerful, and the impact on too many millions of Americans was too thoroughly documented to permit another narrow ruling that sidestepped the real issue. What most people following this story do not realize is that the legal team behind this case came within a single procedural vote of never being heard at the highest level at all. And what happened once it got there is where this story truly begins to get remarkable. Core constitutional questions at the center of the ruling. The questions sitting at the heart of this case sound straightforward when you strip away the legal terminology, but the answers carry consequences that will echo through American law for generations. The fundamental issue was this: can a government force you to navigate costly, time-consuming, discretionary obstacles before you are permitted to exercise a right the Constitution already guarantees you? And if the answer is no for free speech and religion, why has it been yes for the Second Amendment for so long? Here's a data point that makes this tangible. There are currently over 43 million legal gun owners in the United States. In states with the most restrictive permit frameworks, studies estimated that fewer than 5% of those owners could legally carry a firearm outside their own home. That means in some regions of the country, 95% of people who possessed a constitutional right to bear arms were practically prevented from exercising it in public, not because of anything they did wrong, but because the permit process was structured in a way that guaranteed most applicants would fail or surrender before completing it. Beyond the central question about permits, the court also had to wrestle with whether the Second Amendment deserves the same level of judicial protection as other rights in the Bill of Rights. Historically, courts had applied a weaker standard of review to firearms regulations than they applied to restrictions on speech, religion, or due process. The court also had to define what role historical tradition should play in evaluating modern gun laws, a question that had produced wildly inconsistent results in lower courts. With judges in different regions reaching opposite conclusions on nearly identical facts, the answers the majority provided are written into a document that every court in America must now follow. And what those answers actually state caught many people in the legal community completely off guard. The court's majority opinion explained. The majority opinion accomplished something that legal observers on both sides had not fully anticipated. It did not simply rule on the specific permit systems being challenged. It established a clear, detailed framework that applies to firearms regulations broadly, and it did so in language that was deliberately transparent and difficult to reinterpret or circumvent. The core holding was this: when the government restricts a constitutional right, the government carries the burden of proving that restriction is justified, not the citizen carrying the burden of proving their right should be restored. That sounds reasonable, but for decades, it was not how Second Amendment cases actually functioned in practice. Gun owners who challenged permit denials routinely encountered a legal system that treated their right as something they had to earn back, rather than something the government had to justify removing. The majority opinion explicitly rejected that approach and declared it was constitutionally backwards. The opinion referenced data that defenders of permit systems had struggled to counter effectively. Research drawn from 25 states that had already transitioned away from strict permit requirements showed that the predicted surge in gun violence simply never materialized. Of those 25 states, 17 showed no statistically significant change in violent crime rates following the policy shift. The majority also addressed the economic dimension, noting that systems charging hundreds of dollars in fees and imposing lengthy waiting periods disproportionately burden lower-income Americans. A constitutional right that only wealthy or well-connected people can practically access, the majority wrote, is not functioning as a constitutional right at all. It is functioning as a privilege. Now here is the question worth pausing on. Do you believe the government should have to prove why you cannot carry, or should you have to prove why you can? Leave your answer in the comments, because that single question is the fault line that everything else in this debate runs along. Key legal standards clarified or redefined. One of the most practically significant things this ruling accomplishes, something that will matter in courtrooms for decades, is taking the inconsistent collection of legal standards that different courts have been applying to Second Amendment cases and replacing it with one clear framework that every court in the country must now follow. Before this ruling, a study tracking Second Amendment challenge outcomes found that success rates ranged from 31% in some federal court circuits to over 60% in others. Same constitution, same amendment, dramatically different outcomes depending on geography. That kind of inconsistency is not just legally problematic, it is fundamentally unfair to citizens attempting to understand their own rights. The standard the court established centers on what legal scholars call the history and tradition test. Under this framework, when a law restricts Second Amendment rights, courts must evaluate whether that restriction is consistent with the historical tradition of firearm regulation in the United States at the time the amendment was ratified. If the government cannot identify a comparable historical restriction from the founding era, the modern restriction does not satisfy constitutional requirements, regardless of how well-intentioned it might be. This standard has genuine force. It is not sufficient for a state to argue that a law might reduce violence or that legislators believed it would help. Good intentions do not satisfy the test. Historical grounding does. Legal teams representing gun rights organizations have already described this clarified standard as the most powerful legal instrument available to Second Amendment advocates in decades. The implications of having one clear demanding standard applied consistently across all federal courts are enormous, and those implications are about to become very visible at the state level in ways that many lawmakers are only beginning to fully comprehend. Impact on state and local gun permit policies. Across the country right now, state attorneys general and their legal teams are conducting urgent reviews of their own firearms permit laws, attempting to determine which elements of their systems can survive the new constitutional standard and which elements cannot. Research identified 12 states that had constructed their carry permit frameworks almost entirely around official discretion, meaning a government official could deny an application without being required to provide a fully transparent, legally defensible justification. Under the framework this ruling establishes, that kind of system is nearly impossible to defend in court. The numbers behind those discretionary systems reveal a troubling story. In those 12 states, denial rates for carry permit applications were between 3 and 8 times higher than the national average. Lower income applicants, people without the resources to retain attorneys to appeal decisions, and applicants from communities with complicated relationships with local government were denied at significantly higher rates than other groups. The court's majority opinion referenced this pattern as evidence that permit systems were functioning not as neutral safety measures, but as gatekeeping mechanisms producing discriminatory outcomes, regardless of whether discrimination was the explicit intent. At the local level, cities and counties that had layered additional permit requirements on top of already restrictive state systems are in the most legally vulnerable position of all. Several major cities saw new lawsuits filed against their local permit systems within days of this ruling being delivered. The legal pressure is real, it is immediate, and it is arriving from multiple directions simultaneously. Some states are already quietly beginning to revise their laws without making public announcements, which raises serious questions about transparency. But state-level policy changes are really just the backdrop to what matters most, which is what this ruling actually changes right now for someone sitting in a permit office or waiting on an application decision. Immediate changes for permit applicants. If you are an individual gun owner attempting to navigate a permit process right now, here is what you need to understand clearly and practically. This ruling does not eliminate existing permit requirements overnight. States have legal and legislative processes they must complete to bring their laws into compliance, and until those processes conclude, the rules currently on the books in your state are still technically in effect. Following current law in your state, until official guidance changes, remains the correct approach. But here's what has genuinely shifted. The legal foundation underneath the entire permit system has changed, and that shift carries immediate practical meaning for applicants facing unconstitutional barriers. The average total cost of obtaining a carry permit in a restrictive state, when you combine application fees, mandatory training course fees, and processing fees, range between $450 and $600. For a working adult earning the median household income in many restrictive states that represents between 1% and 2% of their entire annual take-home pay just to exercise a constitutional right. No other right in the Bill of Rights carries a price tag like that for ordinary access. Gun rights legal organizations have mobilized rapidly in response to this ruling. Several have established dedicated intake processes specifically for applicants recently denied permits through systems that now appear constitutionally vulnerable. If you or someone you know was denied a permit in the past 12 to 24 months under a system relying heavily on official discretion, there are legal options being actively developed right now that did not exist before this ruling. The practical power balance between permit applicants and permit-denying government officials has shifted, not completely, not overnight, but meaningfully, and in a direction that was not true a month ago. Tell us in the comments, did you expect the political reaction to this ruling to unfold the way it did, or did it surprise you? Reactions from lawmakers and advocacy groups. Within the first 48 hours after this ruling came down, the political response was immediate, loud, and divided along lines that were predictable in direction but surprising in their intensity. Over 30 state legislators across the country issued formal public statements in states with strong gun rights traditions. The dominant tone was celebration paired with calls for immediate legal compliance reviews. 19 state legislators announced formal assessments of their carry laws to ensure alignment with the new constitutional standard. The response from the opposing side was equally swift and considerably more heated. Attorneys general in 8 states issued statements within hours announcing they were exploring every available legal avenue to limit the ruling's practical effect within their borders. Words like catastrophic, reckless, and assault on public safety appeared in official government communications. Several of those statements cited projected harm statistics that independent researchers quickly challenged, pointing out that comparable projections had been made and proven inaccurate when other states made similar policy changes in previous years. Gun rights advocacy organizations adopted a tone that was celebratory but deliberately measured, calling this the most significant Second Amendment legal victory in over a decade, while simultaneously cautioning members that the fight was far from finished. On the opposing side, gun control advocacy groups announced they were preparing both litigation strategies and legislative lobbying campaigns at state and federal levels. What is evident from all of these reactions is that this ruling did not conclude a debate. It intensified one, and underneath all the political noise, something more fundamental is happening to the entire body of Second Amendment law that extends well beyond permits and will reshape the legal landscape in ways most people have not yet considered. Broader implications for Second Amendment jurisprudence. Legal historians studying the development of constitutional rights in America are already placing this ruling in a very brief list of decisions that fundamentally redefined how a specific right is protected going forward. Since 2008, there have been 3 major high court decisions directly addressing Second Amendment rights. Each one raised the constitutional threshold that gun regulations must clear to survive legal challenge. This latest ruling is the strongest and most far-reaching of the 3, and the cumulative effect of all 3 together represents the most significant reshaping of Second Amendment jurisprudence in the history of the country. The downstream effects are already becoming visible. Legal analysts estimate that over 100 lower court cases currently progressing through the federal court system will be directly affected by the standard this ruling established. Magazine capacity limits, certain weapon classification restrictions, mandatory storage laws, and the boundaries of carry-free zones are all now being evaluated against the new historical tradition standard. Legal teams on both sides are scrambling to reassess their arguments in light of what the majority opinion stated, and how broadly its reasoning can be interpreted. For the average gun owner, the practical meaning of this broader shift is significant, even if not immediately visible. Laws that have stood unchallenged for decades because the legal standard for challenging them was too demanding to meet are now positioned in genuine legal vulnerability. That does not mean they will all collapse quickly or easily. Constitutional litigation is slow and expensive, but the direction of travel has been established more clearly than at any prior point, and the instruments available to challenge unconstitutional restrictions are stronger now than they have ever been, which makes what happens next legally, politically, and practically the most important part of this entire story. What comes next? Legal, political, and practical outlook. The next 12 to 18 months are going to be among the most consequential in the recent history of Second Amendment law, and the decisions made during this period by courts, by state legislators, and by individual gun owners are going to determine how this ruling's effects actually manifest in the real world. Legal experts tracking Second Amendment litigation have projected that at least 40 new federal court cases will be filed before the end of this year, directly citing this decision as their primary legal foundation. That is an immediate and aggressive expansion of the legal battlefront that will compel courts across the country to apply the new standard in contexts that extend well beyond the permit question originally before the court. On the political side, gun policy was already ranking as a top 5 issue for voters in 11 states heading into the next major election cycle, and this ruling just added significant momentum to that fire on both sides. Candidates in competitive races are going to be asked directly where they stand, and the answers they provide will be used aggressively by opponents regardless of which direction those answers go. State legislative sessions scheduled for the coming months are already seeing gun policy advance to the top of their agendas in ways that were not anticipated when those sessions were originally planned. For you, as an individual, here is the practical reality right now. First, do not assume the law in your state has already changed. Your state must complete its own process to respond, and until official guidance is issued, existing requirements remain in effect. Second, regardless of what the law requires, invest seriously in your training. Practice consistently and understand your state's specific self-defense laws, because this ruling does not alter them. Third, pay close attention to how your specific state responds over the coming months, because that response will determine how much of this ruling's practical benefit actually reaches you. This ruling opened a door that has been locked for a very long time, and whether that door remains open depends entirely on how engaged and informed gun owners choose to be right now. So here is the final question worth leaving you with. Do you believe this ruling will actually transform how carry rights function in your specific state, or do you think your state will discover a way around it? Drop your honest answer in the comments, because that conversation is one of the most important ones happening in the gun rights community right now, and your perspective genuinely matters. This ruling is just the beginning, and every development that follows is going to matter for your rights as a gun owner. Hit that like button, share your thoughts in the comments, and pass this along to every gun owner you know. Subscribe so you never miss what comes next.